So Hawaii's sensitive places ban on lawful concealed carry is at the Supreme Court for review next week. And while we'll be live tweeting during the oral arguments, we wanted to refresh everyone on the case and remind gun owners what's at stake here. Not only that, but GOA's case Antonyuk v. James was the first case to have enjoined a similar law in New York and helped create the circuit split needed for Wolford v. Lopez to be accepted onto the High Court's docket. So needless to say, we'll be watching these upcoming arguments very closely. I'm Phil, and you're watching Law and Ammo. As our members may know, Wolford isn't the only case we at GOA are concerned about. GOA is currently suing the Department of Justice and ATF over their new $0 tax stamps, a blatant infringement on the Second Amendment rights of Americans. Our One Big Beautiful lawsuit is working to dismantle the National Firearm Act's registration requirements, but we can't do it without your support, and so consider becoming a member today at gunowners.org. Now back to the video. For those of you who haven't seen our previous video on the Supreme Court's most recent Second Amendment case, Wolford v. Lopez, here's what's happening. In the aftermath of the landmark Supreme Court case, New York State Rifle and Pistol Association v. Bruen, states like Hawaii, New York, California, and others were forced to start issuing concealed carry permits on a shall-issue basis. Previously, those states operated on a may-issue system where the state arbitrarily decided whether you could obtain a permit based on if they felt like you needed one or not. And of course, this gave these states an excuse to deny almost all law-abiding gun owners their Second Amendment right to carry a firearm for self-defense. But since the 2022 Bruen case, these states now must issue permits, and they're not happy about it. So in response, anti-gun lawmakers crafted what became known as the Bruen Response Bills, designed to make life as hard as possible for gun owners who had finally gotten the ability to carry their firearms. Whether it was in Hawaii or New York or others, the restrictions were similar, using sensitive places to make it illegal to carry a firearm almost everywhere a concealed carry permit holder might actually go. These states latched onto the idea of sensitive places thanks to language in the Heller case, which said, "Nothing in our opinion should be taken to cast doubt on laws forbidding the carrying of firearms in sensitive places such as schools or government buildings." This was all reiterated in two further Second Amendment cases, McDonald v. City of Chicago, and most recently, New York State Rifle and Pistol Association v. Bruen. And thanks to the Supreme Court's insistence on allowing some places to be gun-free zones, off limits to Second Amendment rights, anti-gun states have decided that it would be better to make their entire state into one big gun-free zone than allowing law-abiding citizens to carry firearms for self-defense. And so, for example, after the passage of their New York's Bruen Response Bill, Governor Hochul was asked about the law and just where gun owners could still carry. Her response? Probably some streets.
Sounds like you're shutting off all of the public places.
I can't shut off all places.
So what would be left?
Probably some streets.
And so we at Gun Owners of America knew this couldn't stand, so we sued. And the win in our case, Antonyuk v. James, set the stage for Wolford v. Lopez by creating the circuit split needed for the Supreme Court to take it up. In fact, Wolford's petition for writ of certiorari to the Supreme Court cites GOA's Antonyuk case on 17 different occasions. That's how similar these cases are. And that brings us to the issue at hand. In all these anti-gun states' attempts to ban carry almost everywhere, they determined they would outlaw carry on private property by default. Referred to as the vampire rule or vampire clause, this provision of state law flips the presumptive ability to carry a firearm everywhere unless there is a posted sign declaring the area a gun-free zone. Flipping that on its head, under the vampire rule, gun owners are by default barred from exercising their Second Amendment rights unless they have express permission by the property owner to carry their firearm. And in case you're wondering where the term vampire clause comes from, according to the stories and books, a vampire is only allowed to enter a home with the express permission of the owner. Anyway, all of this flies in the face of the standard rule in most states where it's accepted that gun owners have permission to carry on private property unless explicitly told not to do so. But that didn't stop New York, California, Maryland, and Hawaii from attempting to implement this insane gun control policy in order to broadly ban firearms in public places. These laws effectively make it impossible to carry for lawful self-defense because most places are off limits. But of course, that's the intent of the law. Anti-gun states don't want their citizens to even own firearms, let alone carry them for self-defense. And that's not just our opinion. In his dissent from the Ninth Circuit's decision in Wolford, which upheld the Hawaii vampire rule, Judge Van Dyke wrote, Hawaii's law prohibits presumptively or outright the carrying of a handgun on 96.4% of the publicly accessible land in Maui County and has effectively nullified the Second Amendment rights of millions of Hawaiians. So now the case is at the Supreme Court and oral arguments are set for Tuesday, January 20th, where we'll get to see what the justices have to say about Hawaii's insane law. A lot is on the line for gun owners in this case. Anti-gun states will use every trick in the book to nullify the Second Amendment. If the Supreme Court gives those states a pass, they'll declare every inch of their states to be sensitive places and outlaw concealed carry entirely. If you want to follow along with our coverage of the oral arguments, make sure to follow our X handle @GunOwners. Thanks for watching.